My name is Andrea Jarman and my co-moderator. All right, we are very honored to have with us the individuals who are running for Washington State Supreme Court. We're going to get right into it so we can maximize our time. So we're going to start off by asking each of the candidates to give a 3-minute introduction of themselves. Judge Larson?
Thank you. And thank you for being here. And thank you for the opportunity. I'm Judge Dave Larson. I've been a judge in federal way for just under 17 years. And before that, I was a trial lawyer for 23 years. My trial practice consisted of civil litigation. My last work before I became a judge was with a large firm doing litigation that require 25 chairs in a conference room to take a deposition. I was national counsel on 15,000 asbestos lawsuits, where I part of a national counsel team to manage discovery nationwide. And I went from that to traffic and misdemeanors. I was the president of the Federal Way School Board, and my Federal Way Municipal Court was in trouble. It was in the newspaper every other day. So the city manager and I talked, and he asked me to come in and settle the court down. There was about a year and a half of turmoil. Then there was an election, and I ended up getting fortunate of working with a benchmate now of Judge Darman, Rebecca Robertson, who won that election, and we turned that court into a pretty good court. And so it's a pleasure to be here, and I want to make sure that everybody understands from my standpoint, I'm not running against somebody, I'm running for the position. And I want to make sure that everybody knows that as far as I'm concerned, Sal and I, and Sal in particular, we've run the type of campaign that I'd like to see us run in politics all over the state. We've been cordial, and I'm just very pleased to have the opportunity to help the public understand this position. And also, if they choose Sal, so be it. If they choose me, then that's great. But let's make sure the public understands our differences and our similarities, so they can make an educated choice. Because I think judicial races are one of the most overlooked races, and they need to be at the forefront. Because the reason the Pledge of Allegiance ends with liberty and justice for all is because you can't have one without the other. And the justice systems are very important to our existence. So thank you for the opportunity again. Thank you.
Thank you, Judge Larson.
Hi, everyone. Sal Punjab. I'm an attorney. I've been practicing for 40 years, civil trial and appellate work, and I am running for the state Supreme Court. So let me just tell you a little bit about myself, some of my values, and some of my support before we get started. I'm the son of immigrants. My dad came from Mexico. My mom came from Japan. I was born in 1959, so that was not exactly the day where we embraced cultural inclusion, celebrated diversity. It was just the opposite. Discrimination was pretty just in your face. I grew up at a time when Japanese were called sneaky and slanty-eyed and buck teeth. Mexicans were dirty and lazy. I saw how my parents were treated, or I should say mistreated, because they didn't have much money. Working class family. My dad was in the army for over 20 years. My mom worked in a fabric store. And they didn't have much money. They had different colored skin. And my mom especially had a heavy Japanese accent. And I remember in second grade, I used to come home from school and watch 2 TV shows. One was a show called Gilligan's Island. And the other was about this attorney who speak up for others. And I saw that because I didn't know any attorneys, and I said, that's what I want to be. That show was Perry Mason, and inspired me to become an attorney. I said, because I'm going to become an attorney, so this stuff doesn't happen to me or my family. So I went straight through undergrad here at PLU, first year at the U at PLU, and went to Georgetown Law School. I graduated with honors before returning to Tacoma, because I'm a Tacoma boy. Did a couple of judicial clerkships, and then joined my law firm in 1986 doing civil trial and appellate work ever since. But let me tell you about my values. One of the first things I started doing was representing people for free, doing pro bono work who otherwise could not afford an attorney. People who have been put down because of the way that they look, because of the color of their skin, because they came from different places, they look different from the mainstream. And I love being that voice for different people, and I've done that consistently throughout my career. I've supported civil legal aid. Was the former president of Legal Aid for Washington, former chair of the Access to Justice Board. I've gone to Washington DC to lobby for more federal funds for civil legal aid. I've gone down to Olympia to lobby our state lawmakers. I am running for this position to hopefully get more access to people who don't have a voice, people who have been marginalized, people who are struggling to be able to even have a house because their rent money has been wrongfully paid. My experience is broad. As I said, civil trial and appellate practice work. I have handled appeals at every level of federal and state appellate courts, including the U.S. Supreme Court. I've represented small businesses. I've represented large businesses against the government, against condemnation action, licensing matters. I've represented aircraft manufacturers and crashes, in addition to representing people who have been injured in air crashes. I have been lucky in my practice. It's my time to get back to the community. And my mantra is, as a judge, and I've already talked to them, to ask me questions, but, for a judge, the judge does is enforce the law. The legislature makes the law, the judge has to follow that law. That's my mantra, and we'll follow it equally, fairly for everyone in our state. And I hope that we have a good discussion.
Thank you. I think it reminded me of what was before. And then we will more compatibility to be the other about the disease. That mind and briefly not the relevant. You talked about your skills and training that you believe would help your confidence about you filling this role, about being all these. And it's open to identity. We're looking for 2 minutes or less.
So you're gonna keep I would love that. I got Dave, I'm going to start on this one. Here's some of I told you about some of my experience. The appellate work has involved constitutional issues with the state and the Supreme Court. Involving First Amendment rights, involving the Commerce Clause, the Taking Clause, Eighth Amendment issues. I've litigated those. I've been lucky. I belong to a couple of organizations, American Board of Trial Advocates and the Litigation Council of America, where you have to be invited to join based upon your ethics and your known legal skills. And I've been members of those two. Since 2011, I've been listed as a quote best lawyer by Best Lawyers in America in appellate practice. I've been listed as a quote super lawyer by Washington Law and Politics since 2008. AB rated by Martindale Hubbell for over 20 years. So that's one. Two, I put myself before different bar associations to go before them, give them my qualifications, give them answer their questionnaire, and then interview by them. And 9 bar associations, 2 have rated me well qualified, 7 well qualified for this position. So I think that's another thing that everybody can look at is the bar ratings to see how you've been rated. But the other thing I want to say is, I've had over 130 judges, throughout the state. We're talking about judges in city, we're talking about judges in rural areas, judges on the spectrum who have endorsed my campaign throughout the state. So I think that's another point of reference. I've been endorsed by 8 of the 9 current state Supreme Court justices. The people who are doing the job now, saying that I have the qualities and qualifications to be that next justice. And I think that's something else that you may want to take into account. So I'll just leave it there. Which you should know about.
Judge Larson, same question.
Thank you. There's multiple things the Supreme Court does. The Supreme Court obviously makes decisions on cases that they accept for review. They're also the prow of the ship when it comes to how the courts operate. They create the court rules. There has to be an understanding of how courts work. There has to be understanding when you're sitting in judgment, when making decisions on the errors that judges make when they're hearing cases. You have to have this perspective of being a judge. But not just in making the cases, but when you're creating rules, when you're talking about managing the courts, you have to have somebody on the Supreme Court that understands how courts work. I'm not going to talk about all the external things. I'm going to talk about the things that make me qualified in terms of the things I want to do and the things I'm capable of doing. I was a civil trial lawyer, as indicated earlier. I handled a lot of jury trials, a lot of things where I saw the perspective of being a lawyer in Superior Court and federal court. I went from that to, like I said, going to municipal court and almost 100% criminal. And it was the most eye-opening thing I've ever seen, most purpose-driven job I've ever had. And I've been wanting to be a Supreme Court justice for quite some time. I decided in 1998 to step away from my practice of insurance defense because the court was more concerned about process than it was about people. And ever since then, it's been a quest. And it's no different now. And the fact that I've been exposed to the criminal justice system, see the areas that we can improve in, and the fact that we don't have a voice on the Supreme Court right now that's paying attention to those issues that are affecting our trial courts. That's what makes me best qualified. I'm also an AV rated trial lawyer. Martindale-Hubbell rated me preeminent as a trial lawyer. I handled complex cases, like I said earlier, cases where you need 25 chairs in a conference room to take one deposition. And so the bottom line is I have the abilities as a lawyer, the legal mind to be able to do it. But most of all, I want the system to represent the people that it's truly supposed to represent. And the fact that I'm not endorsed by 8 of the 9 justices should be important to you because I want change. And I'm challenging the way we operate right now. And that should be telling to you that I'm not supported by those justices because I'm challenging the way we do things. I'm challenging the status quo. I'm challenging the status quo because of what I've been exposed to both in the civil arena, where all of a sudden the rules became more important, where we're litigating rules instead of we're litigating the merits of cases. And also as a criminal trial judge, hearing the stories of people trying to help people change their lives and having our hands tied in a lot of ways because of some of the things that the Supreme Court does. And so ultimately, I'm running for the Supreme Court and I'm qualified for the Supreme Court because of the diverse exposure I've had to the various aspects of the law. And I put myself up there along with anybody else on my ability to reason solid decisions as a justice, but also the fact that I've had to run a court for the last 16 years, understanding how courts are managed. So thank you.
Okay, thank you.
I don't know if mics, you heard there's an echo on Zoom. I
Okay.
apologize.
Okay.
We're gonna
Thank
turn
you.
off all big mics and see if that helps.
Can everybody hear us okay in the room without those?
All right.
Louder.
Okay.
All right, Judge Larson, you just mentioned your current role as a judge at the Federal Way Municipal Court. And by way of context for some of our audience members, municipal court is a court of limited jurisdiction that hears matters like misdemeanor criminal cases, like, for example, DUIs, misdemeanor assault force, traffic infractions, and vehicle impound hearings. The Supreme Court hears a variety of subject matters, many of which are not heard in courts of limited jurisdiction. So the question is, how has your experience as a municipal court judge prepared you for the broader areas of law that will be before you if you are elected to the Supreme Court?
Well, the municipal court position was not a promotion for me. I didn't go from handling small cases to handling municipal court cases. I went from I took that position as a service to my community because our court was in need. Municipal courts the complexity of municipal courts is the volume of work. That's where the complexity is in municipal court. Justice Mattson was Chief Justice for 8 years, and she was a municipal court judge. Justice Owens, who was retiring, who we're replacing, was a part-time district court judge for Forks. So the notion that that municipal court is some kind of lesser court is an example of if people feel that way, is an example of what needs to change, because the municipal courts are some of them, and the district courts are some of the most important courts in our state. Ultimately, what it comes down to in terms of serving as a justice is I again, before I became a judge, and Justice Mattson was a criminal defense attorney before becoming a municipal court judge. Justice Owens, I believe, had a general practice out in Forks. I, again, handled cases that were very complex, and those experiences handling cases that were very of significance, along with sitting on the bench. And like you said earlier, explaining what it's like to be a trial judge is like explaining to somebody what it's like to be a parent. Without that perspective, I remember when the first time I sat as a trial judge, the perspective you have to have is much different than an advocate. So when you're sitting on an appellate court, whether it's Court of Appeals or whether it's the Supreme Court, understanding what has to go through the mind of a judge is absolutely essential to making the proper decisions, both in the legal decisions you're making and the administrative decisions you're making. So I think the municipal court position has given me that skill of being able to understand what goes into the mind of a trial judge, regardless of the context of the case. So I think that it's very useful experience.
Thank you, Larson.
Thank you.
All right, y'all let me know if there's any Zoom issues with this, but I cannot project with the mouse on, so thank you for your patience. Attorney Mujia, you have been a trial and appellate attorney, mostly in private practice, and in areas you set up criminal litigation, civil rights, and plaintiff personal injury litigation. You did say you've never been a judge. So what would you say to the folks here online and other voters who are trying to know, how would you be qualified to sit on the Supreme Court if you've never been a judge?
Three main responses to that. One, it is not unusual for someone not to be a judge to be on our state Supreme Court. I want to make sure everybody understands that. It is not unusual. Some of our best justices were never trial court judges. We're never any type of judges. Mary Fairhurst, one of our chief justices, who was great, was never a judge before. Tom Chambers was another one. Justice Dolliver was another one. They keep on going on and on. So make sure that everybody understands that. Two, remember that on our state Supreme Court, you have 9 members. And what you hopefully want to have people who have variety of experiences, because we all know that the more diverse a body is, the better decisions that they will make. So I will say that we have at least 4 judges who have been trial court judges who are on our state Supreme Court right now. What we don't have a whole lot of it, Justice Stevens had a fair amount of appellate court experience, but other than that, we really don't. We don't have someone who has spent so much time in a private firm, been an owner in that firm, and knows what it's like to represent businesses and individuals, especially businesses against government, businesses against each other, having to deal with governmental regulations. We don't have that experience on the bench right now. We don't have someone who knows what it's like to have to run that business for a number of years with staff, with meeting with payroll, with meeting with taxes. We don't have that. We don't have someone now who has been a former president of the Washington State Bar Association and knows about the regulatory facets of the Bar Association. So what you're trying to do is get a good cohesive team working together. Finally, my third point I want to make, I have served as a neutral for over 30 years as an arbitrator. So again, in municipal court or district court, the limits are very low. So arbitrator, I arbitrate disputes up to $100,000, and I've been doing that for over 30 years, involving personal injury disputes, involving contractual disputes. Remember, I had one medical malpractice dispute within that. So within that arena, I have that experience as well.
Right. This is a question for both of you. I'm going to give some context for the question first. In 2021, the Washington State Supreme Court, in the case of State v. Blake, found that Washington's strict liability drug possession statute, which made possession of controlled substance a felony punishable by up to 5 years with other consequences, it declared that that was unconstitutional because it was without a requirement of proof that the defendant knew they possessed the substance. Can you explain, and this is for starting with you, Attorney Mangia, can you explain the Blake decision in a way that allows the general public to understand the decision, what was the holding, and what concerns, if any, do you have about the Blake decision?
All within 2 minutes. I will do my best. Oh my gosh, it's one of the most controversial decisions we've had in the last few years. So here I'm going to try to do it. Our state Supreme Court, and this is an example of justices having to make hard decisions if they're going to abide by the Constitution. So Washington State had a law which said that in order to be in violation of this drug offense, the state did not have to prove that you knowingly had that drug. So in other words, if I put drugs inside Dua's handbag and then the police stopped her, the mere fact that she possessed it would make her guilty of a Class C felony. 5 years imprisonment, a hefty fine, and other consequences. That came before the state Supreme Court. The court said that violates, and it looked at both the federal constitution and the state constitution and decided it under the state constitution, Article 1, Section 14, and said that violates the state constitution because there is no requirement for the government to prove intent. In other words, we have that situation. It wasn't the only court that came to that decision, albeit there's only one other, and that was in Louisiana, 1989, where the Louisiana Supreme Court held that a similar statute violated its state constitution. But the reason there's only been one other state Supreme Court that has made such a similar ruling is because there's no other state that had such a law on the books. North Dakota was the last state that had such a law in its book that you could just be guilty of a felony for drug possession without the government showing that you knowingly and intentionally had that drug. And the North Dakota legislature changed their law in 1981. So the state Supreme Court said, look, this violates our Constitution, and you know, it's a hard decision. Let me tell you, I know those justices up there, no one wants to have to say that we want to give a more leeway so people can have drugs. Send it back to the state legislature, and all the state legislature had to do is put that intent requirement, which it did, and but then made it a misdemeanor. Now, there's a lot more nuances to that case, but within the 2 minutes, I hope I made you understand that case and its holding, all right?
All right. Thank you, Judge Larson.
Oh, thank you. Yes,
Great.
yes,
Standing ovation.
All right. Judge Larson, related to the Blake case, your campaign website has comments about this decision. I read it verbatim. The Supreme Court remains silent as people and communities suffer. In some ways, the Supreme Court has made matters worse. The best example is the court's Blake decision in 2021, which essentially legalized drugs in Washington. Our state is still trying to recover from that decision, end quote. What concerns do you have about the Blake decision?
Well, first of all, this case is emblematic of what it means to be a judge, because personally, I think it was unfair to not have an intent element. But my personal opinion when it comes to applying the law doesn't matter. In the Blake case, that statute had been upheld in 1981 and 2004 by different Supreme Courts in our state. And then the U.S. Supreme Court said that strict liability statutes are okay. If the Supreme Court didn't like it, they could have put commentary to tell the legislature to change it. But in the majority opinion, Justice Stevens called out the majority because they came up with arguments the lawyers didn't even come up with to declare the law unconstitutional, right? And so all of a sudden, you've imposed your personal opinion, even though that particular decision, even that particular statute had been upheld twice before, you overturn it. Now, you could agree that maybe that was wrong. But the point is the impact that it's had is that for the first 2 years, if you remember, the charge was, the law was you had to be referred to treatment 3 times by a police officer before you could be arrested. It was unenforceable. And so what we saw in our courts, when we're trying to keep people off drugs, we're trying to help people in our therapeutic courts, our drug courts, and everything else. What you saw is that increase in drug use because it's essentially illegal. And talking with, especially people of color, when you're talking to people in that community and they're trying to work with youth to keep people off drugs, and the attitude they're getting back because of Blake, well, it's legal, right? It's not illegal. And so all of a sudden, it undermined our ability to try to actually fix things in our trial courts. And the thing that I have a problem with the Blake case is it's unfair on its face from the standpoint of the justices themselves coming up with arguments the lawyers didn't make. That's unfair to the lawyers and unfair to the parties. Because the bottom line is that for due process to be properly instituted, you need to have an opportunity to be heard. And for judges to come up with arguments or decisions based on what lawyers weren't even arguing, the lawyer should at least be given the respect of responding to those arguments before you make it an official part of a case. Agree or disagree with the outcome, that's fundamental to our existence as judges. I just want us to be judges and justices again and decide cases on the law and the Constitution. The problem with Blake is administratively create problems in the courts because thousands of defendants had to be resentenced. Again, that, if the law is unconstitutional, that sucks to be us that had to happen, right? But ultimately, the biggest issue has to do with the fact that when you have the majority opinion, I like them all, and I agree with Sal, their heart was probably in the right place, but they departed from what it means to be a judge by imposing their opinion, their personal opinion, arguments the lawyers didn't even come up with to come up with the right result. And again, that doesn't mean I dislike them or think they're bad people. It means that I disagree with what they did and the function, how they stepped over the line in terms of the function as a judge. So thank you.
Thank you, Judge Larson. This question is going to be for both candidates, and before I jump into that, just a reminder for everybody in the room and everybody online, if you have any questions and you're online, please drop them in the chat and they will come to us. Anybody in the room, there were note cards up front. If this is raising any questions for you, please grab a note card, jot it down, and we will look at it as well. Okay, for both candidates, starting with Judge Larson, what is your favorite Washington State Supreme Court decision in the past 10 years and why?
Well, I can't remember when McCleary was decided.
12 years ago.
12 years, it's outside the scope of 10 years. But but I actually was as a member of the Federal Way School Board, started the funding litigation in Washington. If you go to the Seattle Times, you'll see an op-ed I wrote in 2006 on the fact that education funding was inadequate in Washington. We were violating the Constitution. We brought a separate lawsuit, Federal Way, called the Fair Funding Lawsuit. McCleary actually did stand up for what was correct, that school funding was inadequate. The way it was handled, I disagreed with in terms of the aftermath, but ultimately the decision was right, and the court was correct in holding the legislators accountable to properly fund education. And I was back in the Federal Way School District back in the 70s when we failed like 27 straight levies, and so I lived it as a student, I lived it as a parent because my kids were in Federal Way schools. I lived as a school board member when on the first night I was a member of the school board, I was asked to cut 26 librarians because of the way schools are funded. And so that was, in 10 plus years, that was my favorite decision.
You know, the reason I knew about how long ago it was, because that's one of my favorite decisions as well. So one of the few times that Dave and I are going to actually agree, actually we agree more than a few times, but McCleary was a monumental decision, and it really sticking up for public funding, necessary public funding, really paying teachers' salaries, which the state had not been doing, as required by the state constitution, was a monumental decision. So.
All right, thank you both. Somewhat relatedly, and this is to both candidates, what barriers do you see for communities of color and impoverished communities in their search for access to justice in the court system?
If I may, sorry, the Zoom folks can't hear the questions very well. So if you can repeat the question, candidates, if you can repeat the question.
Okay.
Prior to answering, you can give a high level repeat of it as well.
Well, why don't I, okay, and I will actually, I have a speech impediment, so it's probably also a combination of that. So the question is, what barriers do you see for communities of color and marginalized communities in their search for access to justice and the court system? And then let us know if that's better.
All right. You know what your impediment is? Color of your skin. Let's face it, we've got bias, both explicit and implicit bias within our communities, and our legal system is part of that community. I could tell you a bunch of studies, and I'll tell you one, I guess, out of Multnomah County, which is where Portland is, done a number of years ago. It's about 8 or 10 years ago, and I'm trying to give you the short version of that, showing in personal injury actions what the jury awards were for white plaintiffs as opposed to plaintiffs of color. And they looked at it two ways. One is known as special damages, so lost wages, medical bills, the like. For like cases, the awards were the same. Where the difference was, though, if you are a person of color and you sue for pain and suffering, you sue for loss of enjoyment of life, in Multnomah County, similar cases, you would get 60 cents on the dollar of what white plaintiffs would get. Okay, there is bias, there is systemic institutional bias within our legal system. I will say this for our state Supreme Court. Our state Supreme Court has been proactive in trying to address bias within the court system because it is known. One of the rules that it adopted a few years ago, which I was lucky enough to work on, I worked on it for 5 years on a committee of 6, which makes it much more difficult to exclude people of color from serving on juries who are otherwise qualified to serve on those juries, which had been a problem and is a problem nationwide. And I will say that Washington State, our Supreme Court adopted that rule. And as a result, 14 other states have adopted a similar rule either by statute or by court rule. So it's a known problem. Action has to be taken. And look at, there's just a lot of work to be done.
Any response to that same question?
Yeah, definitely. The dignity and respect are as important to us as humans as eating, breathing, and sleeping. And the court system does aggravate race issues. What I want to do is make sure we understand how I view access to justice. Access to justice has nothing to do with the courts. It has to do with how we treat each other. It has to do with how we interact with each other. Access to judges and lawyers is something different. And when we get into that aspect, I'm a proponent of what's called procedural justice. I was on the Public Trust and Confidence Committee and proposed that when I first joined. It took 3 years for us to finally adopt it and present it at the fall conference I believe in 2022, at the fall conference to judges. And procedural justice is the way we treat people, the way we treat people in the judiciary. Well, the thing that aggravates racism and aggravates these issues is the way people are treated. They don't feel like they're treated with dignity and respect. They feel that the system's there to boss them around, especially in the criminal justice arena. In family law, we make things sometimes worse than we make it better. And so access to justice for people of color is similar to access to everybody else, but it's aggravated more for people of color because it reinforces some of the things they see in the greater community. And so what needs to happen is we need, in the area of criminal justice, for instance, we need to start with therapeutics and then go to punitive. Right now, we start with punitive, which is basically we're going to punish you, and then when you're out of control, then we'll start paying attention to the therapeutic issues. Where in reality, we need to be therapeutic, and that's what I've done in my court. And people of color that come to my court feel welcomed and feel like it's there to help them have a better life. It's not there to boss them around. It's there to help them have a better life. What the justice system is, the justice system itself is the peacekeeping branch of government. We're supposed to solve problems. We're not supposed to create more. And so the way procedural justice is an answer in the sense that it uses the 4 pillars of procedural justice to then reinforce the fact that the courts don't see it, that people don't see us as the enemy. Trust is something that is engendered in what we do. And so access to justice isn't just access to judges and lawyers, it's access to dignity and respect. It's access to the way you're treated from when you enter a courthouse, what's on the walls, what's in the courtrooms, how are you greeted, how does the judge treat you, how does the clerk treat you. That's how we're going to bridge gaps when it comes to access to justice. Spending money, doing all that stuff, great. A shift in attitude and approach is free. And that's why I'm running for the Supreme Court, because I want to be a voice for those kind of ways to approach things that actually make people feel that the courts are there to help them instead of make their life more difficult.
Can I jump in and take us to a related question as relates to the Washington State Supreme Court open letter of June 2020? In that letter, it called upon each of us in the legal profession to recognize that we all bear responsibility for the ongoing injustice in our legal institutions, and contending that we are all capable of taking steps to address it if we have the courage and the will. So the question is, what do you think about the Supreme Court's recent emphasis on race, challenging each lawyer and judge to help dismantle racism? How will you take on that challenge as a justice? And is that a challenge that you believe you should take on as a justice? And Judge Larson, why don't we start with you?
Well, I'll tell you what I've done in my court, what I think we should do across the state. I'll give you an example. Our court, there was a survey, and our court had the lowest response rate for people of color for jury service. And the state had a study and they responded a certain way. What we did is actual outreach. I worked with my diversity commission, wrote 3 op-eds about jury service, went to what's called the Flavor of Federal Way 2 years in a row with the Minority and Justice Commission to get people to understand, and this is just one example, understand why jury service is so important. The jury I just had last week had 4 of the 6 people were people of color, because it's actual real things you do. The way you treat people in court, it's real. And the Supreme Court has known race has been an issue since the 80s. And the letter in June of 2020, although very important, is just a letter, right? It's what we do that's real in our courts. And like I said earlier, the procedural justice, way you treat people, the way you even address people, that is what's important to get us to the next level. And letters and all that stuff without action mean nothing, mean very little. And that's where we need to go, is we need to go to a system, again, that rethinks itself, rethinks how it approaches people, rethinks how it does things. And Sal's gone off and got money for civil justice to try to buffer some of the expense. Why can't we just make the systems cheaper and easier? Why do we have to provide money to overlay a complicated system that's more concerned about its rules than it is about the service that it's supposed to provide to people? And so my attitude on it is, yeah, it's a starting point. But if you don't have action that goes with it, then it's going to fall on deaf ears.
And Attorney Mangia, same question.
Okay, so there were 3.
Ooh, that's nice.
You can hear me now. The 3 questions. 1, what did I think about the letter? I thought it was tremendous. Make sure that's very clear. That letter was a game changer. You had a unanimous Supreme Court issuing it and taking ownership of discrimination within the legal system. It ain't happened before. It hasn't happened in this country before. It resonated not only throughout our state, but across the country. It really did set some ownership, some leadership within our judiciary. What do I think about the court's role? It's vital. And let me tell you, our court has been doing actions for years. Set up the Minority Justice Commission, which really looks at these issues and does take action. It set up the Access to Justice Board, which just celebrated its 30th anniversary yesterday, making sure that one of the key fundamental parts of the providing access throughout the state is making sure it's done equitably for everybody within the state and paying attention to those who've been marginalized. That's one of the key principles within the Access to Justice Board. What do I think about individual justices taking a role in this? It is critical, and I can look at, again, Chief Justice Gonzalez, Justice Mary Yu, Justice Helen Whitener, and keep on going on and on. These people have been going out and making a difference within the legal community, within the general community. If elected, I've been talking about this, I've been lecturing on this, I've been taking action on this for 38 years, and I plan to keep on doing that if elected to this office.
Back on track? Okay.
Back on track.
All right, I'm going to my co-moderator. All right, y'all. Thank you for your patience with our tech issues this evening. Tech is the new world, right? COVID happened, as evidenced by the folks on Zoom. This is the reality in our courts as well. So we have courtrooms now. Most courtrooms have remote proceedings. So candidates, in considering that folks often have to take off for work, childcare, they have to worry about transportation, getting to work, what is your opinion on the continued use of remote appearance options, and its relationship to an impact upon increasing access to justice, allowing folks to more easily access our judicial system? And we can go in reverse this time, Attorney Mangia and then Judge Larson.
Great. So I am a believer in using technology. We saw how that was used during COVID, and I'll tell you some examples of that. Right now in King County, we have a much more robust system for choosing juries because it's done online. So you don't have to come into the courtroom. It's done online so that people don't have to take time off and can get through that jury selection process. In a lot of the courts that can do it, being able to attend in-court proceedings via Zoom, again, is a huge game changer. Much more efficient. Let me tell you, us attorneys love it, especially when you practice in different counties and you don't have to drive down to Lewis County or go over to Spokane. It doesn't make sense for a 10-minute hearing. It's just not cost effective. So I think all of that has to be balanced. Some things still, in my view, as a trial attorney, if you're doing trials, you can have jury selection, especially if you're set up for that. But as far as, for the most part, doing it within the confines of the courtroom, there is something about the gravity of that courthouse that brings more seriousness to those proceedings. And I do think it's just, you get more from seeing witnesses. You actually get much more communication when you can see the whole body. And so I would say that you always have to balance those things out. But I do see that providing much more access to the justice system. I hope that we continue doing that because that's one of the goals, right? You always want to try to innovate and to be better.
So let me tell you about the practical impacts in court, because I was a judge before the COVID era where we started using Zoom and after. So one of the just common sense things is we have in courts of limited jurisdiction, people that are charged with having a suspended license. Yet we have them drive to court to deal with their case, right? So having them stay on Zoom is just makes sense. Not coming to court makes sense. And so what that's done is it's made it much easier for people to adjudicate cases and in a way that doesn't disrupt their life, as the question points out. We also, what we're doing in our court is we also, a lot of times, people that are in inpatient treatment, we don't know at the time, so sometimes they get warrants. We find out somebody's an inpatient, we do Zoom hearings when they're in inpatient treatment to keep the case moving instead of delaying while they're there. So the benefits of Zoom have been substantial, but we have to keep in mind that in our state constitution, right in the Article 1, Section 22, people have a right to appear in person. So we have to protect that right of people that want to be able to be in court in person, because it is a constitutional right to be there. In certain cases, we require people to be in court, whether it's a warrant quash hearing or different types of hearings, domestic violence, arraignments on violent crime. We require people to be in court. But otherwise, Zoom has been a game changer for a lot of people. It does affect some of the decorum issues, but it's just how we manage. It's just a matter of how we manage the Zoom rather than whether we have Zoom that changes that. But again, it's here to stay. It'll be here forever.
Mm-hmm. Yes, please.
All right, I'm gonna go a little bit out of order. Just a little bit of context for everybody who's tuning in that may not be in the legal community. So the Supreme Court has committees that they can serve on and they can participate in. So this is a question for our candidates to sort of figure out where their interests are in service. So candidates, which committees might you want to serve on if you are elected as a justice? And this time we'll do Judge Larson and then Attorney Mungio.
Well, the first thing I advocate for is the formation of a brand new committee, the Behavioral Health and Justice Commission, to actually deal with behavioral health issues in our courts, because it isn't a priority right now for our court. And I'd want to be on that committee, obviously. But existing committees, probably minority injustice and or gender injustice or minority injustice would be just as appealing to me, because I think that there's some things to, especially being a proponent of procedural justice, because I want that to be the standard in terms of how we handle cases, that to be the default and not be something you have to teach judges, because it becomes something that we learn as lawyers and as judges as we grow up in the system, so that ultimately we have a system that is friendly to people in that way.
Yeah, I would say those two, because one, the Gender and Justice Commission, I served as a liaison for, I think, 6 years from the Access to Justice Board. So I know that commissions work well. They do great work doing research, proposing rules, getting out into the community, and it's just well run. I have not had much dealings with the Minority and Justice Commission, but the few interactions I have had are really exciting. It's followed my work, again, during the 38 years, working on bias issues, speaking out on bias issues to attorneys, to the general public. So that would be another one that I would want to serve on.
All right, well, one of you mentioned standards and one of you mentioned rulemaking. Relatedly, there's been some discussion about public defense caseload standards. I'm sure you've been aware and probably had some thoughts about those discussions and the proposed reduction in the caseloads. Might you share your thoughts about that?
Sure, and I'll go first on this, I guess it's my turn. So just to give everybody a little context on this, this is nothing new, it's been happening for years, but the problem has really become more acute, especially in our state. So you have public defenders, as you all know, under the Constitution, under the federal Constitution, if the government charges you with a crime and you can't afford an attorney, the government has to give you an attorney. Everybody knows that, that's a baseline. Well, the attorney has to be competent and has to be able to provide again, competent representation to you. So in other words, they just can't have a line of clients for you and you get to spend 5 or 10 minutes with your client before you try to represent them. That would not be adequate representation. The problem with this, and let me step back one more second, just so everybody knows as a baseline, we currently have standards for public defenders, caseload standards, both for felonies and for misdemeanors. The last few years, nationally, this has been a problem that has been studied, and there's been national studies showing that the caseloads are too high. Within our own state, the Committee on Public Defense, which has both prosecutors and defense attorneys on it, is evenly balanced, has studied this problem within the state because there's a lot of jurisdictions that cannot retain public defenders because of the caseloads. They are burned out. They are not giving adequate representation. A lot of people accused of crimes keep on going back once a week to court, waiting to get a court-appointed attorney, and nothing happens. So there's a big backlog. Our Committee on Public Defense has studied this and made recommendations, and I'm giving you kind of the big overview here, to the Washington State Bar Association for the process to adopt these standards, these revised standards. The Washington State Bar Association's Board of Governors accepted those proposals. But those are just recommendations to attorneys. They are not binding. But the Washington State Bar Association has forwarded those recommendations to the state Supreme Court. The state Supreme Court now is in the process of determining whether or not to adopt those standards, those revised standards, and if so, what's the timeline? Because now a lot more attorneys will have to be hired. That has already had the state Supreme Court has had one public hearing on this, I think within the last week or two. 26. The comment period is going to close soon, and then they'll have one other public hearing on this. Then the court will consider that, and the court has a lot of options. The court can decide, 1, to adopt them as they are, 2, to reject them as they are, 3, to send them up for further study. There's a lot of things the court can do. We don't know what the court's going to do. We're not on the court. But it is a problem. The court's trying to address it, and this has been studied by people who are practicing within that area, both on the prosecution side and on the defense side.
So we're treating symptoms is what we're doing. We're not dealing with the underlying issue. We have over 300 jurisdictions that are responsible for public defense. It's a low bidder system. So I'm lucky in my jurisdiction that our city didn't go with the low bidder. They went with the better, what they perceived to be the better firm. But when you go to the low bidder, you ended up having a huge disparity between what public defense is paid and what prosecutors are paid. The benefits, everything, all different. And some, like King County, they have in-house, they have pensions and everything else. Most jurisdictions don't. So when you start with training, because if you just imagine any job that you have, and if they just threw you in, said figure it out, how that would contribute to burnout, number 1. Number 2, compensation. Compensation is a big issue. If you're not compensated well enough, plus you don't have the training, don't have the support, what's going to happen to your morale, right? Also, the esteem we give public defense. Sometimes, in fact, public defenders actually bring motions in limine to keep the prosecutor from calling them public defenders because the people, because of the stigma that they perceive that's associated with being public defense. They do one of the most noblest things in our country, to represent people that are accused of crime. So I've written a white paper actually how to have a sustainable system, because you need a funding source, the state needs to be a partner, you need to have a training program that's meaningful. You also, the state can be involved with incentives. If you pay your public defense similar to prosecutors, you'll get some state money. If you form a public defender district, so you can increase the reach to attract more lawyers instead of representing, going to court once a month in some of the jurisdictions, you can have a number of jurisdictions you represent, the state will give you money. If you do things that are beneficial to actually developing a vibrant, significantly competent public defense bar, the state should contribute to encouraging that. Because right now, every jurisdiction, the 39 counties, all the municipalities, it's 320, I believe it is, each are responsible for funding it themselves. And how much of a budget priority is it now? One of the things I'm proposing is to take the last 5 years of how much they spend on public defense, take 75% of that if you form a public defender district, that's your dues. The state picks up the rest, to provide an incentive for local jurisdictions, again, to team together to make sure we can get public defense firms and you could have captured public defense or whatever, or you could have public defense firms. But the point is, it has to be a bigger solution than just reducing caseloads. There has to be an actual look at how we do public defense in the state from the ground up. And if we don't do that, we're just going to continue to treat symptoms. The firm we work with now has 15 lawyers, because they have multiple cities and jurisdictions. They predict they'll need 40 lawyers to meet the new public defense standards. And the local jurisdictions are going to be expected to pay that out of their coffers. Do you think they're going to try to get a lower bidder next time? Try to go cheaper on what's happening with public defense? Yes. And so we have to look at as a bigger issue than just caseload standards. Thanks. And anybody that's interested in seeing the white paper, talk to me afterwards, I'll send it to you.
All right, we are down to our final two pre-prep questions. So, Mr. Attorney Mangia mentioned that he is not yet on the Supreme Court. That is true. However, one of y'all will be shortly. So, very high level, what is your priority? What will be your priority if elected and if you are sitting on the Supreme Court? And I will start this time with Mr. Mangia.
All right, so the three priorities I'll tell you. One is obviously make sure that we adhere to the federal and state constitutions. Make sure that that is always the guiding light. They're applied fairly and equally to everyone within our state. Two, make sure we follow precedent. Precedent is so important to provide reliability and predictability within the law. Precedent has to be respected. Three, again, something I've been committed to, providing greater access to the justice system for everyone within our state. I think that is three main priorities I have.
As I've indicated earlier, there's the couple different things justices do. One is decide cases, the other is help administer the courts and provide leadership and direction. When it comes to making decisions, it's to follow the law and the Constitution the way it's written. As Sal indicated, following the oath is very simple for us. There's two things we swear to uphold: the Constitution of the United States and the Constitution of the State of Washington. That has to be paramount. And we have to understand our role as servants of the people and servants of the law, trustees of the law. When it comes to the administration of justice, the priority, again, is to address, because I've worked successfully with the legislature on a number of things to provide. I wrote a paper in 2019 called Justice Involved Therapeutic Intervention, which inspired my local legislator to get money for local courts for the first time in state history, and we've now up to $30 million for therapeutic courts. But we have to, there's strategies, there's things I've been recognized nationally. I was sent to a summit in Atlanta, Georgia in December by a state representative to be part of the Washington delegation, because of the solutions we can have if we work together, if we have leadership on the court to bring our courts together. I don't want a unified court system, but I want what's called strategy when it comes to dealing with addiction and mental illness. And the Supreme Court is the ideal place to do that, because they're going to have a lot more clout with the legislature to go down and say, there are real solutions we can use in our courts. Early intervention. One of the concepts I came up with is regional resource networks that was funded as a pilot project with the legislature. There's all kinds of things we can do, but when we're indifferent at the Supreme Court level, and again, it's not because I dislike them that I'm saying that, when it's not a priority, then we suffer in the trial courts and we suffer in our communities and the people we serve suffer. It needs to be a priority, and that would be my priority. The first thing I do is sit down with the other justices and say, can we please do this? There are people starving for solutions and starving for your leadership. Please, let's do this. Thank you.
All right, well, thinking about those questions of leadership and role models as you consider this important role to be the seated on the highest seat in our state court system, who are some of your judicial role models? Who do you seek to emulate and why?
Am I going first?
I think we'll go in reverse order.
Okay. I was last time.
Right.
I'm trying to be fair to you.
Yeah.
We're running for judge, so we gotta be fair, right? He's retired, but he was Chief Justice when I became a judge, and that's Chief Justice Alexander. He just and then Justice Fairhurst too. She was Chief Justice just before she passed away, and those two folks are just the symbol of reasonableness, the symbol of calmness. When you're around them, you just feel like you feel trust. It just emulate trust, and they emulate care, and they emulate the love of the law. And both of them are people that I admire a lot.
Great, thank you.
I admire a lot of justices, but at the top of my list, or at least one of the ones that are top of my list, Thurgood Marshall. I mean, the guy was amazing. He's smarter than any all get out. Great civil rights lawyer, great civil rights leader. So successful in argument for the U.S. Supreme Court, then of course got on the bench and made so many changes through his decisions. So that would be one of the top.
All right, thank you both for those responses. We're going to now take some questions from the audience, and that will include some of the questions from the individuals who are participating on the Zoom format. So,
Thank you. I'm going to ask for an awkward ask. If y'all will pass these down to Judge Jarman without looking at them. Little screening of these.
Great, thank you.
All right, so we do have a couple audience questions. There is much talk this evening about diversity, looking at the Zoom folks online, looking around this room. Everybody in this room has experienced issues with being treated differently and may have some opinions about the judicial system. So the question for our candidates is, do you agree that a diverse bench will help the public trust the judiciary more? And if so, we hope you do. If so, what diversity do you plan to bring to the bench? And we're going to reverse again. So, Attorney Mangino.
Yeah, I think it's critical. I mean, I'll tell you, when I started to practice law in 1986, at least private practice, I started in 1984 as a law clerk. But when I started as a practitioner in 1986, the bench was primarily white and primarily male. And back then, we knew it was a huge issue. And so I've always worked to try to bring diversity within the bench because of two main reasons. One, really, people make better decisions if we have diversity. I mean, that's just the sociological studies show that. They prove that out. Two, it's so important for the general public to see people, at least some people that look like them on the bench that have confidence within our legal system. So I think that's critical. I've worked for that throughout my career. What diversity did I bring to the bench? Well, shoot, again, got a mom who was Japanese, a dad who was Mexican, grew up in a working class family. I bring that. Small town, I mean, I grew up in Lakewood, which is a small town outside of Tacoma. Public educated, worked ever since I could start working. I mowed lawns when I was a little kid, and then as soon as I could become a substitute paper route boy, I became a substitute paper route carrier. Before I got my own route at age 12, I bring that. I've worked throughout my life. I worked in a grocery store as soon as I turned age 16. Worked through that during high school and college. As far as diversity, with representing now people who own businesses, small businesses, people who have been in trouble with the government, with licensing, with government taking their property. You know, I bring all those different facets that I think we've talked about tonight to the bench.
I go back to what I've been talking about from the get-go. If we don't change the way we treat people, we can install all kinds of diversity in the system. And if we don't rethink how we do justice in this state, if we don't start with both, I believe in family law and in criminal law especially, if we don't start with the understanding that our job is to solve problems, to give people dignity and respect, to help people have better lives. If we don't do that, you can, and if we don't adopt procedural justice as the standard, we can have a diverse bench, but the people we serve, and that's where my focus is, just like when they talked about getting rid of the bar exam. My number one focus is how is it gonna affect the consumers of the system? I'm not as concerned about who's on the bench as how we treat people when they come to court. I don't care what race you are, what gender you are, if people feel disrespected and they don't trust the system, it won't matter who you put on that bench. We gotta change the way we do things, and we can do it. People are starving for us to do it. People, and just talk to the people that consume our system, that are consumers of it, and they'll be the guide. One of the things that it's frustrating for me is when I talk about some of the solutions, even in my own court, and the first reaction is how it's gonna affect us, instead of how it's gonna affect the people we're supposed to serve. And so if that doesn't become the focus first, then all the diversity of the bench will be meaningless unless we do things that will make those people trust us because of what we do, not who we are, right? The diversity I bring is diversity of thought. I'm a white male, I'm an old white male, and I'm overweight old white male, right? So I don't bring any other diversity other than diversity of thought, which is why 8 of the 9 justices aren't endorsing me. And I don't mind being the wait a minute person, because I think it's important. It's important to have a wait a minute person, especially with the way we run our courts. And I want to be that person. I'm not afraid of it, I'm looking forward to it. Not because I dislike the justices, I like them all, not because I want to create a problem, because the first people I care about are the people we serve. That's who deserve our attention. We need to be last. How it affects us needs to be last. What needs to be first is the impression people have when they leave our courts. Were they treated fairly? Did we solve their problem? Did we make their life better? If we didn't do that, all the other efforts are meaningless. Thank you.
We're gonna do a little mic sharing this evening. So a couple things, there's an audience member with a question we're gonna jump to, and then if you see me on my phone, I'm not being disrespectful. We are screening, there's a console outside screening questions for Zoom, and then also typing them up. So we are combining it all. I see an audience member on our right, and then one in the back. So if you wanna go ahead, please.
Good evening, my name is Attorney Shalice Seacrest. I am the president of the state NAACP, the oldest civil rights organization that is here to make certain that our laws and those that are enforcing our laws and interpreting our laws are making certain that they are color blind. We want to make certain that justice works for all. So my question for you is, if we were to step into your mind, help us understand what steps do you take in making a decision that will ensure that your decision really is fair and impartial. Take us through that decision-making step process.
That is an excellent question, and the first thing you have to do is you have to be the active listener, and you have to understand what the issues are. What are you being asked to do? You have to then be, you have to be in love with the fact that nobody cares about your personal opinion. Nobody cares what you personally think. And it depends on the context. If there's difference in a criminal case, a family law case, and whatever. But really, when you're making a decision, it's making sure you're following the law, making sure you're following the Constitution, making sure you're following rules, all that stuff. But in that process, you don't lose your heart. You make your best decisions when your heart is in balance with your mind. If your mind is too much in control, you make unjust decisions. If your heart is in too much control, you make unjust decisions. You have to make sure that's in balance, so that ultimately, when the people leave, win, lose, or draw, they felt, and this is really what it comes back down to the procedural justice aspect, where they felt like even if they didn't win, they were treated fairly, they were heard, and everything else. That's the most important thing for me when I'm making a decision, is making sure that people are heard, making sure that we follow the rules. But my decision doesn't come across as linear, as just the brain, that it comes from the heart too. And that's what you have to do as a judge, to follow through with making the right decisions. Obviously, in the Supreme Court, you're looking at records, you're looking at something different than face-to-face with people like a trial judge, but the same reasoning applies. When your written decision comes out, people have to know that it came from the right place.
So my process, one, listen. I tell new lawyers that is more important skill than knowing how to speak, all right? Listen. And it's easier said than done, because people always start thinking, oh, once you hear something, you want to react to it. You listen, as far as a neutral, listen to both sides. Two, I slow it down. I get a lot of people saying, oh, what's your decision? Especially on the state Supreme Court, you have time to think about things, right? So you slow down the decision and you think about it, you ponder it. Three, you listen to your colleagues. Okay, you listen to the attorneys who are making both sides, and then you listen to the state Supreme Court. People don't understand this is a collaborative court in the sense that they go back and they hear each other's views. And I want to kind of disabuse some notion if you think that we have a monolithic court, right? That they all think alike. Are you kidding me? There is always dissenting opinions, there's concurring opinions. They have different, there's no one faction. They shift around depending on what issues are, how they're seeing things. So don't get this sense that there's one view on the court, because that's inaccurate. You can look at the decisions and shoot, I've been tracking this decision, especially more closely this past year. And the only decision that I can remember that's been unanimous had one where there's a challenge to a local ordinance, which challenged the local ordinance as far as saying, you know what, your ordinance which prohibited someone parking their car for more than 3 days was unconstitutional because someone was living in that car. There, the court unanimously said, no, that statute was permissible, right? But other than that, there's always differences within that court. And so whether someone's endorsing someone or not, or why they endorse me, I will just say this. I will say that, you know, I think that's based upon my record, not upon my views, because you have a variety of views within that court. And that's where they're endorsing me. Finally, I think that what you want to do is make sure that you are listening to your colleagues. You are trying to understand both sides. I try to do that as a trial attorney. I always say, what are we missing here? What are we missing that the other side sees when we can't settle the dispute? Because we should be able to settle everything, because all it is risk management. As long as people understand the risks, evaluate those risks. So I think that's how I try to come up with a fair decision. Fair really means, in this context, you know, sometimes there are going to be harsh decisions if you're following the Constitution, or you're following the laws that are instituted by the state legislature, right? And I will agree with Dave with that. You know, we don't get to make the laws. The judges have to enforce those laws, whether we like them or not. Oh.
All right, we'll get to you. There's a question in the back. Nope, go ahead, and I'll do one from note card, and we'll jump back. We're gonna do a little back and forth this evening. Please.
Yeah, hello. Hi, thank you very much for hosting this event. Really appreciate it. And Judge Dave Larson, I must admit, yes, you're a very respectful man. I was a state certified interpreter, and I have been in your court a couple of times. And I do appreciate the way you have been handling, you know, the people in your court. That said, I'm also the executive director of the Seattle Rideshare Driver Association. And I have a couple of questions here that pertains to the gig workers. That is of concern to our association. With the rapid growth of the gig economy and the evolving nature of employment in sectors like the rideshare, food delivery, and the freelance worker, there seems to be an increasing debate around the legal classification and rights of gig workers. In light of recent development, what do you foresee as the key challenge or consideration for lawmakers in shaping the next generation of law governing gig workers? How can the judiciary balance the interest of gig economy platform workers and the broader public while ensuring fairness and compliance with the existing labor protection? This is one of the questions. The second question also,
Well, brother, thank you so much for the question. Why don't we go ahead and break it up and allow them to respond to that first portion?
okay.
Thank you so much. That,
All right, so I'm gonna give you a response that you're not gonna like to hear, but judges don't make the laws, all right? So the legislature, or whether it's the city council or the county council, would there be ones who make the laws regarding what gig workers' rights are. Judges don't get to do that. Once those laws are made, it's the judge's duty to enforce those laws again, whether we like them or not, but we can't say, you know what, this isn't fair. This isn't fair to gig workers, so we're gonna start doing this from the bench. Nor would you want that. That's not the judge's role. So I know that you probably want kind of a response saying, oh, A, B, or C, can't, at least in my view, can't give that, especially we can't give you opinions on what matters may come before us as well. Just the way that the system works.
So your question assumed two components to it, lawmakers and judges. And so Sal's right that we don't make the law. We interpret the law the way it's written by lawmakers. And the reason that's so important is because the democratic process ends up, because if there's issues that are going on that are creating wrongs, legislators, city council, whatever, once they know about them and once they believe that it's something that needs to move forward, they're going to create a law that protects people. If there isn't something in place now and there's some injustice being done, there's legislators that will care about that and want to get it out in the forefront. And what ends up happening in the democratic process is because of the way we approach it, we reach a consensus. We end up with laws that all of us need instead of laws that only some of us want. But if you look to the judiciary, the problem with the judiciary, it's only the litigants, the two parties that are involved that get a say, whereas in the legislative process, all kinds of people get a say. And even in the legislative process, you're looking for consensus. In the judicial process, you're looking for a winner or a loser. And if you look at every major decision that's ever been made that's been controversial, there's been years of controversy because when a court does it versus when a legislature does it. Best example is in Washington State with same-sex marriage. It was adopted by referendum. When's the last time there was a protest? Versus what if the Supreme Court had done that? Remember when the US Supreme Court did it, we had people not refusing to give licenses. We had all kinds of problems because the court imposed its view. In Washington State, it was the people that decided that same-sex marriage was legal, and there is little rancor about that. Whether you agree with it or not, that particular aspect of the law, the result is we have a better acceptance of it versus the court ordering it would be something much different. And in the case of your situation, if the court got involved and ordered something, then there would be an injustice because only the litigants would be heard. I hope that answers your question. And the example I use is, I used it because it's controversial. A lot of people have views on that example I used, but ultimately all the controversy worked its way through the democratic process, so you don't have people marching in the streets about those issues. So that was the reason for bringing that up, not because that issue is anything other than it's something that happened in the last few years. But that's why the courts really just need to stay in their lane and decide the law and the Constitution, because the democratic process is disrespected when we don't do that.
Yes, thank you very much. Very quickly, the second question pertains to Ahmed Hassan. Mr. Ahmed here, I have a question, he's an Uber driver also, and the question I'm gonna read on his behalf, and please, he says, I was falsely accused of a crime, a rape, that I did not commit while working as an Uber driver, and my case was ultimately dismissed by the court. However, this accusation has had a lasting impact on my ability to continue working and move forward with my life as an Uber driver. to continue to grow in my work. What steps can be taken to ensure that Uber driver who has faced falsely accusation can be protected from the long term consequences even after their case are dismissed?
You know, I understand the question. I can appreciate the circumstances surrounding the question. There are some limitations, I believe, in terms of what the candidates are able to respond to. And so I'm going to, with that caveat, ask if they feel comfortable responding, not knowing what the current status of that is. I don't.
So it's staying in the lane of the court rather than getting the legislative body. The court, remember, controls court rules. GR 15 deals with sealing court records, doing those kind of things, because when people do background investigations, whatever, the fact that litigation was brought is a public record. You can't tell from looking at it whether somebody is falsely accused or not. So the court, if there was issues with how we handle sealing of records like that, the court could address that without the legislature, because the court has the power to do that. When it comes to legislation, there's statutes that deal with non-conviction data that the state patrol maintains, and there's things of that nature that the legislature controls how that works. So those kind of things that if it's shown that somebody's falsely accused, and if that was a court rule, I haven't looked at GR 15 in a while whether that's in there or not, but if a rule was proposed to the Supreme Court, it would be in our lane to be able to say yes or no to something, or if somebody could show that they're falsely accused, they get the court record sealed. Because there's First Amendment issues, freedom of the press issues, there's cases that you have to go through a five-prong test to decide whether something's sealed or not. But ultimately, in situations like that, that could be a solution that the court has control over in terms of if there's a showing that somebody's been abused in the justice system by being falsely accused of something.
Thank you.
All right. One question from the audience here. I'm going to pass the microphone. And again, I just want to indicate that we're mindful that the candidates have some limitations based upon certain rules, and so that's why not every question is able to be posed. And to the extent that it is posed, if you get an answer like, well, it depends, or there are limitations, just please be respectful. We're trying to make sure that we honor what their requirements are under the candidates. Thank you. Go ahead.
My name is Andre Andrescu. I am a civil litigation attorney. I have a question for Judge Larson in particular. You seem to attribute the increase in crime and drug use in the state of Washington to the Supreme Court's Blake decision. Why is that decision in particular the cause of that increase and not other socioeconomic factors, for example? What empirical data is out there to suggest that?
Well, I'm not saying it's the cause. I said it contributed to it, because that 2-year period where it really was unenforceable, where when the legislature came up with that, they didn't think it through in the sense that there's multiple jurisdictions. So Federal Way saw somebody twice, Des Moines saw somebody twice, Kent saw somebody twice, somebody else saw them. Now they're seen 8 or 9 times and referred to treatment, and there's no intervention. There's no consequence for not going to treatment. So ultimately it became unenforceable from my understanding on the street. From law enforcement standpoint, they just didn't enforce it at all, which, when it's not enforced, increases the use. There's no deterrent, there's no consequence, so it increases the use, which then increases the other consequences that we see. And you know, there's debate about whether the war on drugs, whether it was good or not, and I'm not weighing in on that in the least bit. All I know is what I see in court. All I know is I see the lives that are ruined, that are consumed by addiction, and it breaks your heart to see that happen. And so to have something, to have it be easier for that to happen, and I have to see those people in my court because it was easier for them to get into the addiction that they're suffering from. That bothers me. So yes, it's part of the reason, not the reason. So there are other significant other factors. Culturally, as a culture, we have other issues that we have to deal with that are much deeper. Trauma, medicating trauma is probably the number one thing that's happening on our streets. We're not dealing with the underlying issue. We're not digging deep enough to find out the underlying cause. Even in our courts, we think we can send somebody to inpatient treatment and we've solved the issue. We haven't. There's much deeper.
I'm gonna take a written question that came in a while ago as the mic makes its way around the room. Just
Thank
keep your
you.
hands up. Okay, so we talked about video proceedings, we talked about how Zoom is playing a role in the court. So this question is about AI, that is artificial intelligence. I'm sure many of you know. You search on Google, Google's telling you all the things. You can have AI write papers for you, do presentations. So for our candidates, two-part question, it's two questions, I'm gonna combine them. So high level, how do you believe artificial intelligence will change the work of the Supreme Court? Tying in part B, how do you think this can impact the practice of law, thinking about the shortage of attorneys? So high level, how can it change the work of the court? And then how can it affect the practice of law, things like attorney shortages?
I wish Justice Stevens were here right now, because isn't that one of her big pet projects right now is AI?
It is.
I guess I'm an old codger, but the AI can be of great benefit, but it can be of great abuse too. And I think I don't even know that we comprehend some of the issues that could occur from it. But as long as things are accurate, the law is accurate, the arguments are accurate, the facts are accurate, the things are accurate, and it's serving the consumer of the law, then we should probably look at anything that would help, especially with, the number, and Sal went to we went to law school about the same time, and when I went to law school, when we did research, there was the computerized research, the screen was this big and the computer was this big. And it was a table about this big that had books stacked, from one end to the other when you're trying to do something, and the digest that you have to look at and everything else. It's an experience for the young law students that never had to do that. Now it's so computerized. The books behind me in court are decorations because everything's so computerized. So if you look at that evolution and you go, 30 years ago, 40 years ago, when we were in law school, if somebody said that we could do this now, we'd probably go, well, wait a minute, so you gotta keep an open mind, yet be skeptical enough to not fall into traps that are gonna get us down a wrong path.
AI can, again, I agree this can be a benefit. And we already use AI to a certain extent.
Yeah.
As far as electronic research, put in a search term and, give you cases, ask, give me cases that deal with such and such, and you're gonna get a list of cases. Ones are more on point than not on point. Where it's not gonna come into play is where writing actual opinions. I can tell you that. That is still by the humans, by the justices themselves. And again, I think the only other place I can think of it coming into play, I think there's much more scrutiny, making sure not that there wasn't always, but checking the attorney's work, because we know that some attorneys will just try to have AI draft something and AI will just make up certain facts or make up certain cases. So that has to be looked at very closely.
All right, so we'll take a question from the audience member in the back.
Hi, we have almost more than 100,000 Muslim community in Washington State. My question is, in your opinion, how you guys gonna protect this community from Islamophobia? What is happening right now? So, what is your opinion? If you can share any opinion.
Yeah, and I do think that we have to speak out. I mean, I really believe that. I've done that throughout my career for all communities of color, trying to be allies, trying to get the word out, and trying to defend them. I mean, I just have a track record of my civil rights work. I've been an ACLU cooperative attorney, making sure that civil rights are protected. If elected, I will continue speaking out, especially on those communities that are just discriminated against because of your religious beliefs, because of the color of your skin, because of the way that you talk. I mean, that's why I became an attorney in the first place. That's one of the reasons that I'm running for this position.
So in our Constitution that you're not allowed to have a religious test to hold public office. And why is it there? Because there used to be religious tests to hold public office. You couldn't be Jewish, couldn't be Catholic in some jurisdictions. remember in 1960 when John F. Kennedy was elected president, it was a big controversy because he was Catholic, first Catholic president. So freedom of religion in the First Amendment and freedom of religion in Article 1, Section 11 of our state constitution. Article 1, Section 11 is if you read that, it says absolute right to freedom of conscience, absolute right to freedom of religion. It doesn't mince words in terms of our state constitution, in terms of that ability. And so, and it's the same statute discriminates against race, that prohibits discrimination on race. In the same line, I believe the statute prohibits discrimination based on creed. So when disputes come, number one, it's how we treat people in court. Like I said earlier, there can't be any discrimination how we do that. But when cases come before the court, you have to understand Article 1, Section 11, and the First Amendment are there for a purpose, because the type of abuse that has occurred in history was intended to be prevented by those provisions. And if that abuse continues, it needs to stop. There's been a struggle for thousands of years between people that want to be free and the people that want to dominate and control. And it's no different now. It'll be no different 1,000 years from now. Article 1, Section 32 of our state constitution says a frequent recurrence to fundamental principles is essential to individual right and the perpetuity of free government. And it's there for a reason, because if you don't constantly refresh yourselves in those things, in the abuses that have occurred in history that resulted in the need for the Bill of Rights, that resulted in the need for the Declaration of Rights in our state constitution, then we lose hope that we can truly be free, live side by side, where a Muslim family lives next to a Catholic family, next to a Jewish family, next to it, and we can get along and we can see each other's dignity and respect as individuals and respect each other's conscience for what it is, our personal deep-held beliefs, and for that matter, a lack of belief. Somebody doesn't have to have a religion either. But unless we put that at paramount, the freedom of conscience is the foundation of everything else. If you don't have that, you can't have much else. Because speech, everything else that flows from that. Thank you.
All right, we want to be mindful of the time. I think we'll take one more question for the audience, and then we'll give an opportunity for the two candidates to give some closing remarks. Your question?
Thank you. My name is Mohammad Zahid Chowdhury. I have done lots of court briefs and curiae on both the state, from the county district court, superior court, appellate court, Washington State Supreme Court, and the U.S. court, Ninth Circuit Court of Appeals, and the United States Supreme Court. And I've seen a pattern in the last 25 years. For example, a soldier can file for the United States Supreme Court a petition of certiorari in a booklet form, in a normal form. But I've seen that since 9/11, that right has been denied to Muslim soldiers, sailors, airmen, who are petitioning the United States Supreme Court again and again. So both of you, it's just a legal prowess. It's an intellectual question. It is a federal jurisdiction. It's a different sandbox.
Right.
But just for intellectual exercise, when a department like USCIS makes a secret policy, which is illegal, immoral, unconstitutional, and the case goes on, it's actually U.S. District Court in Seattle for the last 8, 9 years, and everything the government does for FOIA requests and puts under seal, the copies in front of you, Muslims need not apply. We all know where that came from. It used to be blacks need not apply for hundreds of years, whether it be lunch counters or jobs, housing, everything. So after 9/11, the blacks need not apply became Muslims need not apply. It is a different jurisdiction. It's a federal jurisdiction. I just want to know, what do you think about this illegal, unconstitutional policy? Thank you.
We obviously can't give legal
Thank you, brother.
opinions, we talk in general terms,
Chevron case.
but, I talked to you beforehand, and I just alluded to the fact, because in an intellectual discussion, not a legal opinion or anything else, that the Chevron case was decided by the Supreme Court. The question for the legal question that a court would have to resolve is whether or not the regulatory body you're speaking of can create a regulation outside the scope of the legislative grant. But there's a deeper issue, and I'll take it broader than just your question. I've presented now 5 times this thing called How Freedom Works. It's the fundamentals of freedom. It's basically the principles of freedom. No, it removes the partisanship, it removes everything. It's just about principle. And it's based on 2 rules. Rule 1, love the freedom of others as much or more as you love your own. That's rule 1. Rule 2, it's more important to do right than it is to be right. And the reason those rules are so important, regardless of what context you're in, is in the context of government, institutions don't fail people, people fail institutions. Because if people, especially in our country with the foundations that we're based on, if they don't breathe life into those 2 rules, when they're doing everything they do, in terms of even coming up with regulations like you're describing, that the end result of not following those rules are regulations like you described, because they obviously, I haven't seen the reg itself, but if it's not consistent with loving the freedom of others as much more as you love your own, and not consistent of doing right or being right, then it's the people are failing the institution, and we're failing the overall institution of the Constitution and everything else, like we have over and over again in our history. Because remember that struggle has always been between people who want to dominate and control, people who want to be free. You could overlay that at any point in history and see its reality. And it sounds like the situation you're describing is just another one of those realities. Where
I will say history repeats itself, right? History repeats itself. At least where it's personal to me. I mean, I'm not Muslim, but I'm half Japanese, right? And during World War II, Japanese Americans were rounded up, 100,000 citizens, and put in camps. Rounded up and put in camps. Unconstitutionally, in my view. And I think what most legal scholars will say that now. After 9/11, we saw that same kind of things happen in the Muslim community. We saw the federal government rounding up Muslims simply because they're Muslims and detaining them. And what's interesting was they were violating laws. And talk about the federal government violating laws in New Jersey because they were detaining Muslims in New Jersey. And they weren't even disclosing who they were detaining. That violated New Jersey state law. History repeats itself. And that's why it's so important for not just us, but for everybody in this room and everybody listening to protect the Constitution, defend the Constitution, and make sure it's applied equally. Think about putting yourself in the other's position.
All right, thank you everyone who has been attentive and present on the live feed as well as present here in person. We are going to be respectful of the candidates' time and also of your time as well. We're going to go ahead and close this out and allow each of them to give you their final statements, things that you want each of us to leave with that should resonate and we should be thinking about as we make the decisions as to who we should circle in that box for our next justice to be on our Washington State Supreme Court.
I went first, you go first.
I'll go first. I'll gladly go first. Thank you all, first of all, for coming tonight. Those on Zoom, I know this has been somewhat going on. But let me just say a few things. One, I love being a lawyer. I love being changed. So anybody who says, hey, I'm part of the status quo is mischaracterizing me. I have challenged the status quo since I became a lawyer. You don't become an ACLU cooperating attorney if you want to live by the status quo. You don't represent people who are undocumented within this country unless you want to change the status quo. You don't fight for people who otherwise don't have anybody to fight for them unless you don't believe in the status quo. Where I've seen shortcomings within the state Supreme Court where they're rulemaking, I don't just complain about it, I go get a coalition and work the community so that we can get rules changed. You work with your community to get change done. I have done that. I will gladly stand on my record of being a change maker, and I think that's why I've got the support not only of the legal community, not only of judges across the spectrum, again, the political spectrum, against the geographic spectrum. I have the support of labor, the Washington Labor Council, Washington Education Association, Washington Federation of State Employees, among others, because I have fought for change all the time. And anybody who thinks I'm gonna go on the court and vote a certain way is mischaracterizing me, and that is not right. I became a lawyer to make change, and when I was Washington State Bar Association, I always said, lawyers change lives, the legal profession changes society, and that's how I've lived my career, making change. Doing what's right, taking the hard stances. And let me tell you, sometimes they are hard stances. You are in the minority, you are shouting out there because you are trying to make that change. I hope I can have this opportunity to serve on a high court, to make our community better. I've done that throughout my career. I have devoted my time, given my time to others, to causes, to make my community better. And I think it all arises out of the fact that I am the son of immigrants. That is a basic part of who I am. Thank you again for coming.
Thank you, Sal. I'm not doing this for myself. I'm motivated by the people we serve. I'm doing this, I said when I started, I'm not running against Sal. I'm running for the position. Because I think I can bring meaningful change to this state. My hope, regardless of who wins, is that we continue to have conversations and we use each other's energies to affect the change that we need in our court system, right? Because for me, I don't care if I win, lose, or draw. I want change in our system that actually benefits the people that we're supposed to serve. And in the justice system itself, we have an echo chamber. We think that we're serving people. We think we're convincing ourselves of that all the time. But go talk to the people that are actually affected, especially in the area of family law and criminal law, and you'll see that we are failing people. The things that I've been motivated by over the last few years after becoming a trial judge have seen over and over again when people are ready for change and we're not. Where we become the problem. We become the issue. And I've done everything I can to get that changed. I've gotten resistance. Sal and I have something in common. We're both fighters. I'm not going to give up because we can do better. We can do better for our communities. We can do better for our state in terms of how we operate our court system. There's a lot of inside baseball stories I could tell, but ultimately we need to have a Supreme Court that's going to bring our trial courts together, bring our communities together so that we can serve the people that are starving for our service. And we need to get back again to the fundamental reason for courts, and that's to make people's lives better. We have over time allowed our courts to evolve into something we're more concerned about our dogma and the way we operate than we are with the people we serve. And I don't say that because I don't like my fellow benchmates. Every one of them have a big heart. Every one of them want to do the right thing. I'm an immigrant in the criminal justice system. I see where we can do better. I want us to be able to do better. And I want us to be able, again, to serve the people in our state. Nothing I've said has ever been intended to insult my opponent, nor would I. I told Sal from the beginning, I am not going to lose myself in the process of trying to become a justice. I do believe I can add value to the state as a Supreme Court justice, and that's why I'm running. Sal and I disagree on things, but that's good. Disagreement's an opportunity, not a threat. And that's the attitude we have to develop in our culture. Because right now I'm entitled to my opinion, you're entitled to my opinion too. And if you don't agree with me, you must be some kind of whatever. We're so interested in getting our way that we've lost our way. And we need leadership, not only in our courts, but in our other branches of government, to bring us together to actually solve problems, to actually serve the people. I talked about Article 1, Section 1 of the state constitution. Maybe I didn't tonight, but all political power is inherent in the people. Governments derive their just powers, and I emphasize just powers, from the consent of the governed. And the purpose of government is to protect and maintain individual rights. I'll end with a story about how I see elected office. I'm very much involved in civics education. I teach youth, I teach a class called Street Law at Todd Beamer High School this year, twice a week. And I do all kinds of other things. And we were with some students, a bunch of elected officials. One of the students asked, when did you feel closest to your position? And a number of the elected officials went down and talked about different things they did in their official capacity. When it got to me, I talked about being at the end of a line at a chili cook-off. And somebody came up and said, hey, Judge, how you doing? And they talked to me for a few minutes and walked away. The person behind me said, hey, you're a judge, just cut up in front of the line. And I said, actually, when I don't have my robe on, I'm like anybody else. And I told those students, the reason I told you that story is my position is that a citizen first. I play a role as a judge. It's a responsibility, it's not a power. I'm a servant, not a master. And we gotta get back to where Article 1, Section 1 of our state constitution, life is breathed into that, to where we have people in office that care about the responsibility they hold rather than the power they acquire. And the reason we're having problems now is because it's all about power. It's all about control. And it needs to be about what's right. The two rules, love the freedom of others as much or more as you love your own. It's more important to do right than to be right. That's what I promise you. That's the creed that I will live by as a justice. I appreciate the opportunity, and again, there needs to be more of this because the judiciary is very important. It's very important that Sal's views get out there, that my views get out there so people can make an educated choice. And I'm just grateful for the opportunity. Thanks.
All right, let's thank both of our candidates, please, again, for being here and sharing their time and their thoughts. And that's exactly why we wanted to do this, because it really is very important. We cannot emphasize enough that you pay attention to the judicial races. You can find additional information about each of these candidates at their various websites. Correct? Correct. Okay, all right. I want to thank the committee organizers, and I also want to thank my lovely and brilliant co-moderator, Dua. All right, thanks everyone. We'll ask that you, if you can, for those of you who are able, can help us to stack the chairs up so we can get out of this venue on time and be respectful of the individuals who are also here working late at night for us to host this. Thank you, everyone. Assalamu alaikum.